Hey everyone. It's been about a week and a half since the Supreme Court issued a ruling that a Texas law banning nearly all abortions can remain in effect while legal challenges are ongoing. So I thought it might be a good idea to make a video about that. Problem is, abortion is such an enduringly contentious issue that I have only a snowball's chance in hell of adding anything meaningful to the discussion. So instead, why not broaden my scope a bit and talk about the Supreme Court as an institution? What it's supposed to accomplish for us, how it became so central to debates over certain cultural issues, and whether it should be. When I started making notes for this video, I thought something along the following lines was going to happen. I was going to read a couple of the Federalist papers to see what some of the framers had to say on these questions about the Supreme Court. And because what they were doing was so historically unprecedented, there would inevitably be glaring miscalculations I could point to and say, see, if we could just fix this thing that the founders got wrong all the way back in the before time, we could get out of this mess and stop trying to rip each other's heads off every day. Well, I read Federalist 78, the main article in that series that focused on the federal judiciary, as well as a couple of others, and guess what? It's a little more complicated than that. In Federalist 78, Alexander Hamilton argued, among other things, that of the three branches of government, the judicial branch is inherently the least threatening because it doesn't have any independent means to enforce its will. The president has all of the guns, and Congress has the checkbook, while all the courts have is the respect people give them. However, this only holds true for Hamilton when these three functions of government are actually separated. As soon as the judiciary merges with either the legislative or executive authority, all hell breaks loose. Interestingly, Hamilton didn't really entertain the idea that the judiciary could become dominant over the other branches by improperly exercising, say, legislative authority. He only worried that the Supreme Court would come to be dominated by another branch, because, again, the courts are inherently weaker than the other branches. And yet, in recent years, we've seen various liberal elements complain that 5 or 6 judges in D.C. have more authority to decide what the law says than people's democratically elected representatives. That argument has been making the rounds recently after the abortion decision, for example. And even though I'm usually not fond of invoking both sidesism to prove a point, conservatives did say precisely the same thing about gay marriage and the like a few years before this. So there's agreement, at least situationally, that something has gone wrong with the Supreme Court. The court, which is supposed to be a fair arbiter of what the Constitution and laws of this country really say, has become just another blunt weapon in partisan combat. Meanwhile, there are few consolidated democracies in the world where the highest court is anywhere near this controversial, and almost never for reasons of sheer partisanship. America has a unique problem with its Supreme Court, and it's not obvious why. Let's look at a couple of proposed explanations and solutions. One idea for getting out of this mess is to do away with lifetime appointments to the Supreme Court in favor of having justices be appointed for a fixed term. This way, the thinking goes, judicial appointments will become routine and lower stakes, so that presidents are under far less pressure to appoint rabid partisans to the court. This idea is mainly popular among left-leaning people, for the moment at least, as it's mainly gained traction after former President Trump appointed 3 Supreme Court justices during his term, all of them under controversial circumstances, to put it politely. It seems like a reasonable suggestion to me, but Hamilton warned that this would have the opposite effect of what we want. One of the main points of Federalist 78 is that lifetime judicial appointments are essential for making the court system truly independent of the other branches of government. If a judge is only appointed for a certain number of years, and at the end of their term, they only stay in office if elected officials decide to reappoint them, then that easily leads to judges being too likely to defer to the wishes of the person who gets to reappoint them. So Hamilton argued. So both sides of this disagreement have reasonable sounding arguments for why their position on how long judges should serve will help lead to a Supreme Court that isn't a dumpster fire. As a tiebreaker, I decided to look up how other constitutions handle this because, as mentioned previously, there are democracies in the world other than the United States, and their high courts are not dumpster fires. And my very informal research on the question yielded a decisive, uncontestable, There are stable democracies that take both approaches to judicial terms. Maybe there's some kind of effect and we should consider fixed terms for judges in the US, but this question doesn't appear to be the main factor behind our Supreme Court woes. What about who appoints members of the Supreme Court? In Federalist 76, Hamilton argued that the system in our Constitution for appointing judges and other officers gains a variety of benefits from a single person, the president, making all of the decisions about who to nominate to each post, while negating most of the flaws of a single appointer by filtering those nominations through the advice and consent of the Senate. Some of Hamilton's arguments sound really convincing right up until the moment you remember that both the presidency and the Senate have become overcome with severe partisanship, which makes it way less surprising that the Supreme Court confirmation process has become acutely polarized. Maybe a good solution would be to entrust at least part of the judicial appointment process to a nonpartisan board of legal experts who can suggest highly qualified and non-threatening candidates for the Supreme Court. This is how a lot of other democracies get judges for their non-dumpster fire high courts, and some have suggested that maybe it would work here. If you have apolitical people nominating Supreme Court justices, there's way less opportunity for party politics to seep into the appointment process. Simple. There are problems with this, of course. Probably the most obvious is that this approach does compromise on how democratic your constitutional system is. In a democracy, you want all major officials to take office only with the approval of the voters, even if indirectly. One layer of separation with something like the president appointing officials or parliament choosing the prime minister is usually acceptable, but having an elected official appoint some technocrats who then go on to appoint your judges, it's not hard to make the case that some degree of democratic control is being sacrificed here. In Federalist 76, Hamilton made a somewhat different argument about transparency and accountability, but I'm not going to go into that one because the existence of political parties, once again, totally undermines it. Noticing a theme here. More convincingly, though, there are other democracies, such as Germany, the Czech Republic, and Costa Rica, where elected officials are directly responsible for appointing judges. And you never hear about German judicial nominees in international news. One other observation that I think lands closer to the mark is that the American Supreme Court is entrusted with a really broad area of responsibility compared to other countries' high courts. The Supreme Court effectively serves as a final court of appeal for any federal case or any state case involving federal law or the U.S. Constitution. If they're able to freely pick up cases from such a huge space of litigation, it's not surprising that they frequently take on high-profile issues that some people would prefer to be handled by the elected branches of government. This direction for potential reform is especially appealing because we wouldn't need a constitutional amendment to actually get it done. Congress has the authority to limit the Supreme Court's appellate jurisdiction. It's right there in Article 3, Section 2 of the Constitution. It's absolutely something that could be done within the Constitution as it exists right now. But it seems like there's an extremely small chance this will be tried. And it seems like the reasons it realistically isn't going to happen have a lot to do with why the Supreme Court is so contentious in the first place. The more I look into the arguments about how to fix the Supreme Court, the more I become convinced that the real problem isn't with the Supreme Court itself. The poison is seeping in from another part of the constitutional framework. But since this video is supposed to be about the Supreme Court, I'm going to leave off there for now. In my next video, we're going to track the problem to what I think is its true source, and maybe we'll even find a realistic way to make things a little better. Anyway, that's my bit. If you hated this video, then please leave a thumbs down and tell me about it in the comments. If you didn't, then I really would appreciate if you would subscribe and share this video with someone you think would get something out of it. See you later.